So imagine you're sitting in a jail cell.
Okay. Not the best start to the day.
No, definitely not. You haven't been formally charged with anything yet, but you are the prime suspect in this major bank robbery.
Right.
And the guy on the bunk next to you, he seems friendly enough. He starts asking you what you're in for, how your day is going.
Just making casual conversation.
Exactly. And before you know it, you're venting. You tell him exactly how you pulled off the heist.
Oh, no.
Yeah. But you figure you're safe, right? Because you haven't been given a lawyer yet. You haven't been to court, and you're just talking to another inmate.
Right, just a guy.
But what you don't know is that your new friend is actually a police informant wearing a wire.
Wow.
Yeah, placed in that cell specifically to get you to talk.
Yeah.
So the big question is, did the state just violate the United States Constitution?
I mean, it's the kind of scenario that feels like it should have a super simple, straightforward answer.
You would think so, like a hard line in the sand.
Exactly. You'd think there's a clear line regarding when the state can and cannot try to extract a confession from you. But the reality is that the Constitution just doesn't operate like a light switch.
Right.
It operates much more like this incredibly complex, highly conditional set of interlocking gears.
Okay, I like that analogy.
Yeah, because depending on tiny, seemingly insignificant variables, like whether that informant asked you a direct question or just laid there and listened, the entire legal outcome completely shifts.
And understanding exactly how those gears turn is our mission today. We are taking a comprehensive, custom deep dive into one of the most thoroughly misunderstood and honestly, highly tested areas of criminal law.
The Sixth Amendment right to counsel.
Yes. So if you are preparing for the multi-state bar examination, the MBE, this is an area where examiners just love to set incredibly subtle traps for you.
Oh, they absolutely do.
And even if you aren't taking a legal exam, understanding the exact mechanics of your fundamental rights is just essential knowledge.
For sure.
We are going to take the dense, often contradictory rules from the Supreme Court source material and break down exactly how they function in plain English. We'll cover when the right actually kicks in, who gets to represent you, how you can accidentally waive the right, the offense-specific rules, and what happens if your lawyer is just terrible at their job.
Because when you read the actual text of the Sixth Amendment, I mean, it sounds incredibly brief and absolute.
It's just one sentence, really.
Right. But it actually guarantees an entire package of rights to anyone accused of a crime.
Like what kind of package?
Well, it dictates that you have the right to a speedy and public trial.
Okay.
It says you have the right to an impartial jury. It guarantees you the right to be informed of the nature and cause of the accusation, the right to confront the witnesses testifying against you.
Right, cross-examination.
Exactly, and the right to compel your own witnesses to appear. And then finally, the right to have the assistance of counsel for your defense.
And it's that final clause, the assistance of counsel, that creates this massive web of case law.
It really does.
Because for a long time in American history, that clause was interpreted simply to mean that the government couldn't stop you from bringing a lawyer into the courtroom, right? If you could afford to hire one.
Exactly. For over a century, the prevailing legal thought was essentially, well, if you have money to pay an attorney, the state will let them speak for you.
Which is nice if you're rich.
Right. But it completely ignored the reality of the criminal justice system. A vast majority of defendants are indigent.
Meaning they can't afford private counsel.
Right. They have no money for a lawyer. So the landscape shifted dramatically, most famously with Gideon v. Wainwright in 1963.
Oh, classic case.
Yeah, Clarence Earl Gideon was an impoverished man charged with a felony in Florida. He asked the trial judge to appoint him a lawyer because he couldn't afford one.
And the judge just said no.
Yeah, the judge refused. He stated that Florida law only required appointed counsel in capital cases, meaning cases where the death penalty was on the table.
Wow.
So Gideon had to represent himself, did poorly against a trained prosecutor, and was sentenced to 5 years in prison.
And then from his prison cell, he famously wrote a petition to the Supreme Court, right? Like in pencil on prison stationery.
He did. And the Supreme Court actually took his case and ultimately ruled that the Sixth Amendment's guarantee of counsel is a fundamental right essential to a fair trial.
That's a huge shift.
It was massive. They held that the 14th Amendment's Due Process Clause incorporates this right, making it obligatory upon the states.
Okay, let's pause right there, because incorporation is a term that gets thrown around a lot in constitutional law. Let's explain the mechanism of how that actually works for the listener.
Good idea.
Because the Bill of Rights originally only applied to the federal government, right?
That's right. When the founders wrote the Bill of Rights, it was a restriction on federal power. If the federal government arrested you, they had to respect your Sixth Amendment rights.
But if the state of Florida or New York arrested you?
The federal Constitution didn't explicitly protect you from state actions back then. It wasn't until after the Civil War, with the passage of the 14th Amendment, that this changed. The 14th Amendment says that no state shall deprive any person of life, liberty, or property without due process of law.
So the Supreme Court essentially used the 14th Amendment as a bridge. They said, look, a fair trial is a fundamental part of due process.
Wow.
You can't have a fair trial without a lawyer. Therefore, the 14th Amendment forces the states to provide lawyers, just like the Sixth Amendment forces the federal government.
That is precisely how incorporation works. It took the federal guarantee and applied it to local state courthouses.
Got it.
But Gideon only involved a felony. The court had to figure out exactly how far down the spectrum of crimes this right extended.
Right, because does a state have to pay for a lawyer if you're just facing, like, a tiny fine for a speeding ticket?
Exactly.
And this brings us to our first major threshold rule, a concept that is absolutely vital to recap if you're staring down a multiple-choice question on the MBE.
Definitely.
The Supreme Court established a bright-line rule regarding exactly what kind of punishment triggers the constitutional requirement for an appointed lawyer.
Right. So the rule is that the Sixth Amendment right to appointed counsel applies in any case where the defendant is actually sentenced to a term of incarceration.
So it's about the actual sentence.
Yes, this was solidified in cases like Scott v. Illinois. If a defendant is charged with a misdemeanor, and the statute says the punishment could be up to a year in jail, but the judge ultimately only sentences them to pay a $500 fine.
Then no lawyer was required.
Exactly. The state did not violate the Constitution by failing to provide a lawyer. The actual punishment imposed is what dictates the retroactive necessity of the lawyer.
So the trigger is the actual loss of liberty. You cannot be locked in a cage without the state having provided you with an attorney to fight against that outcome.
Spot on.
But there is a massive trap here that bar examiners love to exploit.
Oh, the suspended sentence trap.
Yes. Let's say I am convicted of a low-level offense. The judge looks at me and says, I am sentencing you to 30 days in the county jail. However, I am suspending that sentence entirely on the condition that you complete 1 year of probation without getting into any more trouble.
Okay.
I walk out the front door of the courthouse. I'm not in a cage. Did the state need to provide me with a lawyer for that trial?
Yes, they absolutely did. This was the central issue in a Supreme Court case called Alabama v. Shelton.
So even though I'm free, I needed a lawyer.
Right. The court ruled that a suspended sentence that may end up in the actual deprivation of a person's liberty cannot be imposed unless the defendant was accorded the guiding hand of counsel.
Because even though I walked out the front door, the sword of Damocles is now officially hanging over my head.
Exactly. The 30-day jail sentence is a formal reality. If you violate your probation by missing a meeting or failing a drug test, the state doesn't have to put you on trial again to prove you committed a crime.
They just pulled the trigger on the 30 days.
Right. They just activate the 30-day sentence that is already on the books.
Yeah.
Because that term of incarceration was formally attached to your punishment, the initial trial that resulted in that sentence required a lawyer.
And if you didn't have one?
Then that suspended sentence is unconstitutional and cannot be enforced.
Okay, so if we are locking down the baseline for the MBE, you get a lawyer, even if you can't afford one. If the state ends up attaching any term of incarceration to you, whether you serve it immediately or it's held in reserve,
That's the rule.
that establishes the what. Now we really need to look at the when, because the timing of this right is arguably the most confusing aspect of the entire Sixth Amendment.
Oh, it is incredibly counterintuitive, and largely because our cultural understanding of the law is shaped almost entirely by police procedurals on TV.
Right. Like on every single cop show, a suspect gets chased down an alley, tackled into a chain-link fence, handcuffed, and dragged into an interrogation room.
Classic scene.
A grizzled detective walks in, throws a folder on the table, and the suspect immediately shouts, "I'm not saying a word, I want my lawyer."
Right.
And the scene cuts, the lawyer shows up, and the interrogation is over. That creates this deeply ingrained idea that the Sixth Amendment right to counsel is something you actively demand the moment the police put their hands on you.
But legally, what you just described from TV has almost nothing to do with the Sixth Amendment.
Wait, really?
Yeah. That suspect shouting, "I want my lawyer," in an interrogation room is actually invoking their Fifth Amendment right against self-incrimination.
Okay, we really need to pull these two amendments apart and look at the wiring. because confusing them is fatal on a law exam. How does the Fifth Amendment right to counsel work compared to the Sixth?
Well, the Fifth Amendment right to counsel was created by the Supreme Court in the landmark Miranda v. Arizona decision.
Right, Miranda rights.
Yeah. It is a prophylactic rule designed to protect your right to remain silent when you are subjected to custodial interrogation.
So you have to be in custody.
Exactly. If the police have you in custody and they are actively questioning you, the environment is considered inherently coercive. To offset that coercion, the court said you have the right to have a lawyer present during that specific questioning.
Okay.
But here's the key difference for the MBU. The Fifth Amendment right to counsel only exists if you actively invoke it. You have to assert it out loud.
You have to say the magic words.
Yes. But the Sixth Amendment right to counsel operates on an entirely different track. It is the right to have a lawyer assist in your overall defense against a criminal prosecution.
How do you get it?
Unlike the Fifth, the Sixth Amendment right does not need to be actively invoked by the defendant. It deploys automatically.
Automatic. But the catch is that it deploys incredibly late in the game, right?
Exactly. The Sixth Amendment right automatically attaches, that's the legal term, attaches only after formal judicial proceedings have begun. This is the rule from Rothgary v. Gillespie County.
Okay, let's explore what formal judicial proceedings actually means in the real world. Let's go back to my TV scenario. I am tackled in an alley by a police officer. I am arrested. I am sitting in the back of a squad car. Have formal judicial proceedings begun? Has my Sixth Amendment right attached?
No. An arrest alone does not start the Sixth Amendment clock.
Really? But I'm in handcuffs.
The police have seized your person, yes, but the state has not yet formally committed to prosecuting you. At that moment, you are still just a suspect in an ongoing investigation.
What if I sit in a holding cell overnight? The detectives are absolutely convinced I did it. They are gathering evidence. Does the shield deploy then?
Still no. The Supreme Court has drawn a very strict line. The right attaches when the government changes its role from merely investigating a crime to actively and formally accusing you of one.
So how do they do that?
This happens through specific procedural events. A post-arrest initial appearance before a judge, the filing of a formal charge, a preliminary hearing to determine probable cause, the handing down of an indictment by a grand jury, or an arraignment where you are brought before the court to enter a plea.
Okay, so it is the literal moment the prosecutor formally steps onto the battlefield and files the paperwork that says, the state versus you.
That's the mechanism. Once that formal accusation happens, the entire dynamic of the relationship changes. You are no longer just a target of police suspicion. You are a formal adversary of the state.
And I say it has a lot of resources.
Exactly. The government has unleashed its immense legal machinery against you. The Constitution recognizes that an average citizen is entirely unequipped to face that machinery alone, so the Sixth Amendment automatically provides you with a legal expert to level the playing field.
But just because the shield is activated, does that mean it covers absolutely everything that happens from that point forward? Like, let's say I've been indicted. Formal proceedings have begun. My right has attached. Do I now get to drag my lawyer with me every single time I interact with the police or the legal system?
No, the protection is not a blanket that smothers the entire process. The Supreme Court has clarified that once the right attaches, you are only guaranteed the presence of counsel at what they call critical stages of the prosecution.
We need to define critical stage, because to a defendant facing prison time, literally every moment feels critical. Yeah.
Of course. But to the courts, a critical stage is defined as any proceeding between an individual and an agent of the state that amounts to a trial-like confrontation, at which counsel would help the accused in coping with legal problems or meeting their adversary.
Okay.
It's about whether the absence of a lawyer might derogate from the accused's right to a fair trial later on.
Let's run through some concrete examples from the source material and test this logic. What is definitively a critical stage?
The most obvious ones are the courtroom proceedings themselves. Arraignments, preliminary hearings where probable cause to prosecute is determined, bail hearings, pretrial motions arguing over what evidence should be allowed, plea bargaining sessions with the prosecutor, the trial itself, and the sentencing hearing.
Right. That makes perfect sense.
Yeah.
Those are all moments where you are actively sparring with the state, where legal rights can be lost, and where the outcome of the case is being directly shaped. You need a lawyer there to cope with those legal problems.
Exactly.
But let's look at the investigative stages that happen after an indictment. Let's say I am indicted for a robbery, so my Sixth Amendment right has attached.
Okay.
The police want to put me in a live physical lineup to see if the victim can pick me out. Is that a critical stage?
Yes. Post-indictment lineups and in-person identifications are explicitly designated as critical stages. This was established in United States v. Wade.
Let's unpack the why behind that. Why is standing on a stage behind two-way glass considered a trial-like confrontation where I need a lawyer? I'm not answering legal questions. I'm literally just standing there.
Well, the Supreme Court recognized that human memory and eyewitness identification are incredibly malleable and subject to suggestion.
Okay.
A live lineup is a dynamic, fluid event. It happens exactly once. If the police structure that lineup in a way that is wildly unfair, for example, if you are 6 feet tall and everyone else in the lineup is 5'2".
That would be pretty obvious.
Right. Or if the police officer subtly nods his head when the victim looks at you, that unfairness might result in a false identification.
And once a victim points at you and says, that's him, that image is basically burned into their brain for the actual trial.
Precisely. And more importantly, if you don't have a lawyer present in that room to observe the lineup, it becomes almost impossible to prove later at trial that the lineup was actually unfair.
Because it's just your word against the police?
Exactly. The lawyer isn't there to object or stop the lineup. They're there as an observer to witness the procedure so they can effectively cross-examine the victim and the police about it later at trial.
Oh, I see.
Because the lineup can permanently taint the trial outcome, it is a critical stage.
Now, let's contrast that with a situation that bar examiners constantly use as a decoy.
I know exactly what you're going to say.
What if, instead of a live lineup, the police take a folder of 6 photographs, including a mugshot of me, and show it to the victim? Is a post-indictment photo array a critical stage?
It is not. You do not have a Sixth Amendment right to have your lawyer present when a witness is viewing a photo array, even if you have already been formally indicted.
If I'm a student trying to memorize the rules, that feels completely contradictory. Both procedures involve a victim looking at my face to identify me. Why does a live body require a lawyer, but a picture of a live body doesn't?
It all comes back to the ability to reconstruct the event at trial.
Reconstruct it.
Yeah. A live lineup disappears the moment it's over. But a photo array is static evidence. It's a physical folder of pictures. If the police put together a terribly unfair photo array, say, your picture is a high-definition color photo, and the other 5 are blurry black and white photos of people who look nothing like you.
The defense attorney doesn't need to have been standing in the room to know it was unfair.
Exactly. Months later at the trial, the defense attorney can simply ask the prosecutor to hand over the folder, hold those exact same photos up to the jury, and say, look at how suggestive this was.
Wow, okay.
The legal problem can be fully addressed at trial without the lawyer having been present at the time the photos were actually viewed.
That distinction is brilliant. It's all about the preservation of evidence. If the unfairness can be perfectly preserved and challenged later, you don't need a lawyer present in the moment.
You've got it.
So following that logic, what other procedures are considered non-critical stages where the Sixth Amendment doesn't apply?
Things that involve gathering scientific or physical evidence, taking your fingerprints, making you provide handwriting exemplars or voice exemplars, or drawing your blood for DNA testing.
Because my lawyer can't stand there and advise my fingerprints on how to look.
Exactly. Fingerprints and blood are what they are. There is no strategic legal maneuvering involved in providing a blood sample. The analysis of that blood might be challenged later at trial, but the physical act of drawing it is not a trial-like confrontation.
We also need to talk about the appellate process, because the timeline doesn't end at a guilty verdict. Let's say I lose my trial. I want to appeal my conviction to a higher court. I'm indigent. Does my Sixth Amendment right to counsel cover my appeals?
This is a tremendous trap on the MBA.
Okay, hit me.
The answer is that you do have a constitutional right to an appointed attorney for your first direct appeal, the appeal that state law grants you as a matter of right.
Okay, so I get a lawyer.
Yes. However, the Supreme Court has ruled that this right does not actually stem from the Sixth Amendment.
Wait, where does it come from?
It comes from the Equal Protection Clause and the Due Process Clause of the 14th Amendment. This was established in a case called Douglas v. California.
What's the logic there?
The logic is that if a state creates a system where everyone has the right to appeal a conviction, they cannot operate that system in a way that makes it meaningful only for wealthy defendants who can afford to hire appellate lawyers.
That makes sense.
An indigent defendant without a lawyer is essentially blocked from participating in the appellate process. Therefore, equal protection demands that the state provide a lawyer to ensure the process is fundamentally fair.
So if I get a multiple choice question asking which constitutional provision guarantees an indigent defendant the right to appointed counsel for their first direct appeal, the answer is the 14th Amendment Equal Protection Clause, not the 6th Amendment.
That is exactly right.
Why not the 6th, though?
Because the Sixth Amendment specifically says, in all criminal prosecutions, the Supreme Court has interpreted a prosecution to essentially end when a defendant is convicted and sentenced.
Ah, so an appeal is not a prosecution.
Right. It is the defendant trying to overturn a prosecution. Therefore, the Sixth Amendment doesn't apply. And because of that, the equal protection right only extends to that first mandatory appeal.
What if I lose that first one?
If you lose your first appeal and you want to petition the state Supreme Court or the U.S. Supreme Court to hear your case, which are discretionary appeals, meaning the court gets to choose whether to listen to you or not, the state has absolutely no constitutional obligation to provide you with a free lawyer for those efforts. You are on your own.
And the same goes for post-conviction proceedings, like parole hearings, probation hearings, or filing habeas corpus petitions from prison. You generally do not have a constitutional right to an appointed lawyer for those, correct?
Correct. The state has already successfully prosecuted you. The Sixth Amendment shield has largely powered down, with one tiny exception.
What's the exception?
If a probation revocation hearing involves the actual imposition of a new sentence that wasn't previously determined, you might get a lawyer. But generally, post-conviction is a lonely place for indigent defendants.
Let's do an MBE need-to-know recap of this attachment phase for the listener.
Okay.
The Sixth Amendment is a powerful defense system, but it stays dormant until the state formally commits to going to war with you by initiating formal judicial proceedings, like an indictment.
Right.
Once it's active, it only deploys to protect you during trial-like confrontations, not during the routine gathering of physical evidence or photo identifications. And if you're appealing a conviction, you get a lawyer for the first round, but you thank the Equal Protection Clause, not the Sixth Amendment.
That covers the timeline perfectly.
Awesome. So we've established exactly when the right kicks in and what stages it covers. Now we need to look at the personnel.
The cast of characters.
Exactly. Who actually gets to stand next to you at the defense table? This is where the constitutional theory slams into the economic reality of the justice system. Does the Constitution care how much money you have?
Oh, when it comes to choosing your lawyer, it cares immensely. The rules are fundamentally divided based on whether a defendant is wealthy enough to hire their own counsel or indigent and relying on the state.
Let's start with the defendant who has financial resources. What does the Sixth Amendment guarantee them?
It guarantees them the right to the counsel of their choice. This is a very robust right, detailed in cases like United States v. Gonzalez-Lopez. If you have the money, you can hire whoever you want to represent you, provided they meet certain baseline criteria.
What are those criteria? Can I get incredibly creative?
What's your hypo?
Let's say I am an eccentric billionaire. I've been indicted for a massive, incomprehensibly complex financial crime involving offshore tax shelters. I have a brilliant accountant who has worked for me for 30 years. He knows the tax code better than any lawyer on earth.
Okay.
He understands my business inside and out. Can I use my Sixth Amendment right to counsel of my choice to force the trial judge to let my accountant represent me as my lead attorney in federal court?
Absolutely not. The Supreme Court is unequivocal that the term counsel in the Sixth Amendment inherently means a licensed member of the bar.
So no accountants?
No accountants. It implies a person trained in the law and subject to the ethical rules and disciplinary oversight of the legal profession. A person who is not a licensed attorney cannot represent anyone but themselves in a court of law.
But he's so smart.
Your accountant can sit behind you in the gallery. He can testify as an expert witness. He can crunch numbers in the hallway, but he cannot sit at the counsel table, file legal motions, or speak to the judge on your behalf as your legal representative.
Okay, so they must be a lawyer. What if I find the most ruthless, brilliant defense attorney in the country? She wins every case. I have a blank check. But she completely despises me.
Well, that's a problem.
Right. She finds my alleged crimes morally repugnant and refuses to take my calls. Can I waive my Sixth Amendment right to counsel of choice at the judge and say, the Constitution says I get the lawyer I want, so force her to take my money and defend me?
No, you cannot. The right to counsel of choice is the right to hire a willing attorney. The 13th Amendment prohibits involuntary servitude. You cannot conscript a private citizen into working for you, even if you are offering them an absolute fortune. The lawyer must agree to take your case.
Let's look at a scenario where everyone is willing. I have the money. I found a brilliant lawyer who is licensed to practice. She desperately wants to take my case.
Okay, sounds good so far.
Can the state ever step in and break up that relationship? Can a judge veto my choice?
Yes, under a very specific and highly tested set of circumstances, a court can deny a defendant their chosen, willing, paid counsel if that lawyer has a serious conflict of interest.
Like, why does the judge care? If it's my money, my lawyer, and my life on the line, shouldn't I be allowed to make a bad decision and hire a conflicted lawyer if I want to?
Well, in a case called Wheat v. United States, the Supreme Court explained that the judiciary has an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them.
So it's about optics.
Optics and integrity. Let's say you and your business partner are both indicted for the same crime. You both want to hire the exact same high-powered defense attorney.
Okay, to save money.
Right. The judge can look at that and say, if this goes to trial, one of you might need to testify against the other to save yourself. This lawyer cannot ethically cross-examine one of their own clients to help the other client.
That makes sense.
The conflict of interest is so severe that it threatens the structural integrity of the trial. Even if you and your partner jump up and down and say, we waived the conflict, we don't care, the judge has the authority to disqualify the lawyer and force you to hire someone else.
That makes sense.
Yeah.
The system has to protect its own reputation and integrity, even against a defendant's wishes. Now let's look at the other side of the economic divide.
The indigent defendant.
Right. What if I am completely broke? I am indigent. The state is appointing a public defender for me. Can I choose which public defender I get? Can I say, I've heard great things about Sarah in the public defender's office. I want her, not John.
No. An indigent defendant is entitled to the assistance of an effective advocate, but they are entirely without the right to the appointment of counsel of their own choosing.
So you get what you get.
The state's constitutional obligation is to provide you with a competent lawyer to ensure the trial is fair. Their obligation is not to cater to your preferences, personalities, or whims. You get the attorney the court assigns to you. If you don't like them, but they are legally competent, you are stuck with them.
What if I decide I don't want a lawyer at all? Like, what if I look at the public defender they assign me, decide I could do a much better job myself, and tell the judge I want to go it alone? I want to act as my own lawyer.
You have the constitutional right to do exactly that.
Really?
Yes. The right to represent yourself is known as proceeding pro se. The Supreme Court recognized this in a landmark 1975 case called Ferretta v. California.
What happened in Ferretta?
Anthony Ferretta was accused of grand theft. He was appointed a public defender, but he believed the public defender's office had too heavy a caseload to properly defend him. So he asked to represent himself. The trial judge eventually forced him to use the public defender anyway, and Ferretta was convicted.
And the Supreme Court overturned it.
They did. They overturned the conviction.
But what was their reasoning? I mean, if the Sixth Amendment is about ensuring a fair trial, isn't an amateur representing themselves almost guaranteeing an unfair trial?
The court acknowledged that. They said a defendant who represents themselves is likely going to do a terrible job, but they ruled that the Sixth Amendment right to counsel is a tool provided to the defendant, not a mandate forced upon them.
So it's about choice.
It's about autonomy. The right to defend oneself is a personal right of immense historical importance. To force a lawyer upon a defendant who truly wants to steer their own ship, even if they steer it straight into an iceberg, deprives them of their dignity and autonomy. The government cannot compel a citizen to accept an advocate they do not want.
But I imagine the judge can't just shrug, say good luck, and let you step in front of a jury.
Yeah.
There has to be a mechanism to ensure you aren't just making a rash decision in a moment of panic.
There is a very rigorous mechanism. To validly waive the right to counsel and proceed pro se, the waiver must be knowing, voluntary, and intelligent.
How do they test that?
The trial judge is legally required to conduct a thorough colloquy, which is a formal conversation on the record with the defendant. The judge must explicitly warn the defendant of the profound dangers and disadvantages of self-representation.
What exactly are they warning them about? What does that conversation sound like?
The judge will lay out the brutal realities. They will say, do you understand that the prosecutor is a trained, highly experienced lawyer who will not hold back? Do you understand that you will be bound by the exact same complex rules of evidence and courtroom procedure as a licensed attorney, and that I, as the judge, cannot help you, give you advice, or explain how to object?
Basically trying to scare them straight.
The goal is to make sure the defendant's eyes are wide open to the catastrophic risk they are taking.
And there is a specific, highly testable warning they must give regarding appeals, right?
Yes. The judge must warn the defendant that if they choose to represent themselves, they completely waive the ability to raise an ineffective assistance of counsel claim on appeal later.
So you can't blame yourself.
Exactly. You cannot act as your own lawyer, do an incredibly incompetent job, get convicted, and then complain to the appellate court, "My trial was unfair because my lawyer was terrible." You assume the total risk of your own incompetence.
Now, I've heard of something called standby counsel. If a judge is terrified that a pro se defendant is going to turn the trial into a complete circus, can they assign a lawyer to just sit near them, just in case?
Yes. Even if a defendant validly waives their right to counsel and passionately insists on going it alone, the trial judge has the authority to appoint standby counsel.
Even if the defendant doesn't want them there.
Crucially, they can do this even over the defendant's loud and persistent objections.
What exactly is the role of standby counsel then? Are they co-captains of the ship?
Not at all. The defendant is still entirely in charge of their own defense. Standby counsel is exactly what it sounds like. They sit in the gallery or at the edge of the defense table. They serve two purposes. First, they are there to aid the accused if and when the accused requests help with a specific legal procedure or rule.
Like having a legal encyclopedia sitting next to you that you can choose to open or ignore.
Exactly. But their second, and arguably more important function for the court, is to act as an understudy.
In case things go wrong.
Right. If the pro se defendant becomes overly disruptive, refuses to follow basic courtroom decorum, or repeatedly violates the judge's orders, the judge can terminate the self-representation right there in the middle of the trial.
Wow. Just pull the plug.
Yeah, and if that happens, the standby counsel is ready to seamlessly step in and take over the defense without the court having to declare a mistrial and start over from scratch months later.
That makes perfect sense from an efficiency standpoint. There's one more nuance regarding pro se representation that bar examiners love, and it involves mental competency.
A very tricky area.
We know there is a legal standard for being competent to stand trial. A defendant has to understand the charges against them and be able to minimally assist their lawyer. But what if a defendant meets that standard but then says, "Okay, I understand what's happening. Now I want to fire my lawyer and represent myself"? Does the judge have to let them?
Not necessarily, and this was a huge development in a 2008 case called Indiana v. Edwards.
What are the facts there?
Ahmaud Edwards was suffering from severe schizophrenia. He was caught trying to steal a pair of shoes and shot a security guard. He had multiple competency hearings. Eventually, with medication, the court determined he was competent enough to stand trial with the help of a lawyer.
So he understood he was on trial for shooting someone.
Right. But then, Edwards asked to represent himself. He filed rambling, completely incomprehensible legal motions. The trial judge denied his request, forced a lawyer on him, and he was convicted.
Did the Supreme Court uphold that? Because under Ferretta, we just said you have the autonomy to steer your own ship.
The Supreme Court actually upheld the trial judge's decision to force a lawyer on him. They created a distinction in the law. They ruled that the standard for being mentally competent to stand trial is lower than the standard for being mentally competent to represent yourself.
Why is there a difference?
Because standing trial just requires passive understanding and the ability to talk to your lawyer. But actually representing yourself involves complex, active tasks. Formulating a defense strategy, examining witnesses, arguing motions, addressing a jury.
How will it work?
A defendant might be legally sane enough to be put on trial, but still suffer from a severe mental illness that makes them completely incapable of carrying out the basic tasks needed to present a defense.
So letting them do it would be bad.
Exactly. In those specific cases, permitting them to represent themselves wouldn't be honoring their dignity. It would be allowing a public spectacle that makes a mockery of the justice system. So the judge can deny the pro se request and force them to use counsel.
Let's recap this for the MB listener. Wealthy defendants get their choice of willing, unconflicted lawyers. Indigent defendants get competent lawyers, but not their preference. Anyone can choose to represent themselves, provided they get the severe warnings about waiving future appeals, and provided they are mentally competent enough to actually perform the tasks of a lawyer, not just competent enough to sit quietly at the defense table.
That perfectly encapsulates the personnel rules of the Sixth Amendment.
Which transitions us beautifully into our next major topic, waiving the right outside the courtroom. We just talked about the incredibly rigorous process of waiving the right in open court, the judge looking you in the eye, the formal colloquy, the dire warnings.
Right.
But what happens out in the wild? What happens if the police try to talk to you after your Sixth Amendment right is attached, but before your trial begins? Can you accidentally give up this massive constitutional shield?
The mechanics of waiving the Sixth Amendment during police interactions are arguably the most counterintuitive part of this entire area of law. Let's start with the standard requirement. Just like any constitutional right, the Sixth Amendment right to counsel can be waived by a defendant. The overarching rule, established in cases like Patterson v. Illinois, is that a waiver is valid as long as it is voluntary, knowing, and intelligent.
Voluntary, knowing, and intelligent. It's the golden trio of waiver standards. But what does it actually require the police to do? If the Sixth Amendment right is so much more powerful than the Fifth Amendment right, and if waiving it in court requires a judge to give you a terrifying speech, you would assume the police have to jump through massive hoops to get you to waive it in an interrogation room.
You would think so.
Do they have to read you some special supercharged Sixth Amendment warning?
This is where the source material drops a bombshell that trips up almost everyone. They do not. The Supreme Court has explicitly stated that standard Miranda warnings are sufficient.
Wait, Miranda warnings? You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. Those were created specifically for the Fifth Amendment right against self-incrimination.
Yes, they were. But the Supreme Court took a highly pragmatic approach in Patterson. They said that the core purpose of the Sixth Amendment during post-indictment questioning is to protect the defendant from making foolish statements without legal advice.
Right.
Well, what do Miranda warnings do? They tell the defendant exactly that. You don't have to talk, and you can have a lawyer here if you want one. The court ruled that an accused who is given proper Miranda warnings has been sufficiently apprised of the nature of their Sixth Amendment rights and the consequences of abandoning them.
So Miranda pulls double duty. If I am indicted, my Sixth Amendment right attaches. The police bring me in. They read me the standard Miranda card. I say, yeah, I understand my rights. I don't need my lawyer here. I'll talk to you. I just successfully waived my Sixth Amendment right.
Exactly. The waiver is considered knowing and intelligent simply because you received the Miranda warnings. Now, it still must be voluntary.
Of course.
The police still cannot use physical force, torture, sleep deprivation, or extreme psychological coercion to force you to sign that waiver. The Due Process Clause always prevents involuntary confessions. But assuming the police just ask you nicely and you agree, the Sixth Amendment shield drops, and they can question you without your lawyer present.
Okay, that establishes the basic waiver. But now we need to wade into what I call the trap.
Oh, Edwards versus Montejo.
Yes, we are going to compare how the Fifth Amendment handles someone changing their mind versus how the Sixth Amendment handles it. This involves overturned Supreme Court precedent, which examiners adore.
It is complex, but if we break it down sequentially, the logic emerges. Let's look at the Fifth Amendment rule first, which is often called the Edwards Rule from Edwards v. Arizona.
Is that the stage for the Edwards Rule?
Okay, you are arrested. You are sitting in a police interrogation room. You haven't been charged, so no Sixth Amendment yet. The police read you, Miranda. Instead of waiving it, you say, I want a lawyer. You have just affirmatively invoked your Fifth Amendment right to counsel. Under Edwards, the moment those words leave your mouth, the police must immediately stop questioning you.
That's the hard stuff.
But Edwards goes further. It creates a rigid prophylactic rule. Once you invoke that Fifth Amendment right, the police are absolutely forbidden from initiating any further interrogation about any crime until your lawyer is present.
Any crime.
Any crime. They cannot come back 3 hours later, read you Miranda again, and see if you've changed your mind. If they do and you sign a waiver, the courts will presume that waiver was involuntary because it was the product of police badgering. The only way the police can talk to you without a lawyer is if you initiate the conversation.
Okay, the Fifth Amendment rule is incredibly protective. Once you ask for the shield, the police are not allowed to even try to talk you into lowering it. They are locked out. Now let's look at the Sixth Amendment. How does it differ?
For a long time, it didn't differ at all. In 1986, the Supreme Court decided a case called Michigan v. Jackson. They took that strict Edwards do not touch rule and copy-pasted it onto the Sixth Amendment.
So what was the logic there?
The logic was, if a defendant has been formally charged and the court has appointed them a lawyer, the state knows they are represented. Therefore, the police should be strictly forbidden from initiating questioning without that lawyer present. Any waiver obtained by police-initiated questioning was presumed invalid.
That makes logical sense. If the state formally recognizes you have a lawyer, the state shouldn't be sending detectives to sneak around behind that lawyer's back to get a waiver.
It made sense to the court for 23 years. But then in 2009, a case came along called Montejo v. Louisiana that completely shattered that rule.
What happened with Montejo?
Jesse Montejo was arrested for murder. He was brought before a judge for a preliminary hearing. Under Louisiana law, because he was indigent, the judge simply looked at him and automatically appointed a public defender to his case.
Okay.
Montejo never spoke. He never asked for a lawyer. The system just assigned him one automatically. Later that day, before Montejo ever met his new lawyer, detectives approached him, read him Miranda, asked if he would help them find the murder weapon, and he agreed. He ended up writing an apology letter to the victim's widow.
And under the old Michigan v. Jackson rule, those detectives shouldn't have been allowed to approach him, right? Because he had an appointed lawyer.
Exactly. His lawyers appealed, arguing the apology letter was obtained in violation of his Sixth Amendment rights because the police initiated the conversation after counsel was appointed. But the Supreme Court used this case to entirely overturn Michigan v. Jackson.
Wait, why? What was the flaw in the old rule?
The court realized that in many modern judicial systems, lawyers are appointed administratively. A judge or a clerk just assigns a public defender to a file. The defendant never actively raises their hand and asserts their desire to deal with the police only through counsel.
Right.
The court reasoned that the strict do not touch rule was designed to protect defendants who had affirmatively asserted their right. If a defendant never actually asked for help, it doesn't make sense to presume that they are incapable of voluntarily waiving their rights later just because a clerk put a lawyer's name on their file.
So what does the Montejo ruling mean for defendants and police today? What is the current rule?
The current rule is that simply having an appointed lawyer under the Sixth Amendment does not permanently immunize you from police-initiated questioning.
Wow.
If your Sixth Amendment right has attached, but you have not actively, affirmatively told the police or the court that you refuse to speak without your lawyer, there is no presumption that a subsequent waiver is invalid.
Put that in a real-world scenario. Let's say I'm indicted. I'm assigned a public defender. I make bail, and I'm sitting at home watching TV.
The police can legally drive to your house, knock on your front door, and say, hey, we know you have a lawyer for your upcoming trial, but we're wondering if you'd be willing to just chat with us about the case right now without your lawyer here. We have to read you your Miranda rights first. If they read you the rights and you say, sure, I'll talk, you have validly waived your Sixth Amendment right.
Even though my lawyer has no idea this conversation's happening.
Yes. The Edwards strict do not touch rule only applies if you are in police custody and you actively demand a lawyer. If you are out on bail, you are not in custody. Therefore, the police can approach you, and as long as they don't coerce you, they can ask you to waive your Sixth Amendment right. The burden is entirely on the defendant to say no.
That is a massive paradigm shift. It means the Sixth Amendment shield is highly vulnerable to smooth-talking detectives if the defendant doesn't stand firm.
Oh, definitely.
Okay, let's look at one more scenario involving police behavior. What if the police aren't just smooth-talking me? What if they are actively hiding things from me?
Let's hear it.
Let's say I'm sitting in an interrogation room. I haven't asked for a lawyer yet, but my family panicked and hired a lawyer for me. That lawyer is standing in the lobby of the police station, desperately telling the desk sergeant, I represent the man in room 3. Do not question him. Put me on the phone with him right now.
Oh, dramatic.
Right. The detectives in the room with me know my lawyer is in the lobby, but they intentionally don't tell me. They just read me Miranda, and I waive my rights and confess. Is that a violation?
This exact scenario happened in a case called Moran v. Bourbon. And the answer depends entirely on our timeline from earlier. Has the Sixth Amendment right formally attached yet?
Let's say it hasn't. It's an hour after my arrest. No formal charges, no arraignment, just an ongoing investigation.
Then the police's behavior is completely legal and your confession will be used against you. In Moran v. Bourbon, the Supreme Court held that the police are under no constitutional obligation to inform a suspect that an attorney has been trying to reach them. Your Fifth Amendment Miranda right is personal to you. It is your right to remain silent and your right to ask for a lawyer.
Right.
If you don't ask for one, the police don't have to act as a message service for a lawyer your family hired. The police are allowed to keep you in the dark to secure a confession as long as the Sixth Amendment hasn't attached.
That feels incredibly deceptive and unfair to the lawyer in the lobby.
It is widely considered an aggressive and deceptive tactic, but it is legally permissible pre-attachment. However, if the Sixth Amendment right has attached, let's say you were indicted the day before, you were arrested on the warrant, and your lawyer is in the lobby, the dynamic changes completely.
So what happens then?
Once the Sixth Amendment is active, the state has a duty to respect the attorney-client relationship. Deliberately interfering with that relationship by hiding your lawyer from you while seeking a waiver would almost certainly render that waiver invalid.
So recap for the MBE listener. If I am an exam taker, I need to look at the timeline before I judge the police's behavior. If it's pre-attachment, the police can be deceptive about lawyers in the lobby. If it's post-attachment, that deception probably violates the Sixth Amendment.
Exactly. You always have to ask, is the shield officially powered on?
Let's move to our next major topic, which explores the limits of that shield once it is powered on. We're talking about the offense-specific rule.
This is a big one.
Let's say I've done everything right. I've been formally indicted. My Sixth Amendment right has attached. I have a lawyer, and I have explicitly told the police, the judge, and the world that I will only speak through my lawyer. Does my lawyer act as a magical umbrella that protects me from being questioned about anything and everything?
No. And this is perhaps the most defining structural characteristic of the Sixth Amendment. The Supreme Court laid this out definitively in a case called McNeil v. Wisconsin. The rule is that the Sixth Amendment right to counsel is entirely offense-specific.
Meaning what, exactly?
It means that once the right is invoked and attaches, it applies only to the specific crime that the state has formally charged you with in those proceedings. It does not provide blanket, generalized protection against police questioning for other unrelated, uncharged crimes you might have committed.
We need to use the Dave example from the source material because it is the perfect illustration of how this rule interacts with the Fifth Amendment traps we just discussed. Let's walk through Dave's incredibly bad week.
Okay. Defendant Dave is arrested and formally charged with burglary. He goes to his arraignment, gets a lawyer, and makes bail. Because he has been formally charged, his Sixth Amendment right to counsel has officially attached for the burglary.
The shield is up, but it only says burglary on the front of it.
Right. Now, the police detectives across town have a completely separate investigation going. They suspect Dave committed a major arson a few weeks ago. Dave hasn't been arrested or charged with the arson. He is just a person of interest.
So the Sixth Amendment shield does not exist for the arson yet.
Correct. The police decide to bring Dave into the station to question him specifically about the arson. Dave is now in police custody in an interrogation room. The police read him his Miranda warnings. Dave waives his right to remain silent. He says he's willing to talk, but he says, you know what, before we talk, I want to see my attorney.
Okay, let's pause. Dave is in custody. He is being interrogated. He just asked for a lawyer. That is a clear affirmative invocation of his Fifth Amendment right to counsel under the Edwards rule.
Exactly. The Fifth Amendment shield has just been deployed. Under Edwards, the police must stop questioning immediately. But the police in this scenario decide to act terribly. They ignore Dave's request. They do not call his attorney. They aggressively continue to interrogate him, badgering him for hours, until Dave finally breaks down and gives a full confession to the arson.
The police clearly broke the rules, but which rules? Did they violate his Sixth Amendment right?
They did not violate his Sixth Amendment right to counsel.
If I am a student reading that fact pattern, my brain immediately screams that the Sixth Amendment was violated because Dave literally had a lawyer for his burglary charge, and the police questioned him without that lawyer.
And that is exactly why examiners use this scenario. It feels wrong, but legally, the Sixth Amendment was not violated because the right is offense-specific. The arson investigation was completely unrelated to the burglary charge. Because Dave had not been formally charged with the arson, the Sixth Amendment had not attached to the arson. Therefore, the police could not have violated a Sixth Amendment right that didn't even exist yet.
That is beautifully technical. But Dave isn't just out of luck, right? His confession to the arson is still getting thrown out of court.
Yes, the confession will be suppressed, but it will be suppressed solely because the police violated his Fifth Amendment right. Because he was in custody and specifically requested a lawyer under Miranda, the police were required to stop. Because they didn't, the confession is tainted.
So if a multiple choice question asks, did the police violate Dave's Sixth Amendment rights? The answer is definitively no.
Exactly. You must be incredibly precise about which constitutional shield is currently active and what exactly it covers.
That raises a massive practical question. How does the law determine if two crimes are the same offense or unrelated offenses? Because criminals rarely commit just one neat, isolated crime. If I get indicted for robbing a bank, is stealing the getaway car a separate offense? Or is it part of the same offense? Does my bank robbery shield cover the car theft?
To solve this, the Supreme Court, in a case called Texas v. Cobb, adopted a very specific test that was originally created for double jeopardy cases in a 1932 case called Blockberger v. United States. It is universally known in criminal law as the Blockberger test.
Explain the mechanics of the Blockberger test. How do we measure if two crimes are the same?
The test states that two crimes committed in the same criminal transaction are deemed to be the same offense for Sixth Amendment purposes, unless each offense requires proof of an element that the other does not.
Okay, I need an analogy here, because elements can sound very abstract.
Think of a criminal charge as a recipe. The elements of the crime are the required ingredients. The prosecutor has to prove to the jury that every single ingredient is present to get a conviction. Let's look at two classic crimes to see how they compare: larceny and robbery.
Okay, larceny is basically just stealing something. What is the recipe for larceny?
The elements or ingredients of larceny are: 1. Taking and carrying away someone else's property; 2. Without their consent; 3. With the intent to permanently deprive them of it. If the prosecutor proves those three things, you are guilty of larceny. Now, let's look at the recipe for robbery. The elements of robbery are: 1. Taking someone else's property; 2. Without consent; 3. With the intent to permanently deprive, A and D 4. Accomplishing this taking by using physical force or the threat of force against the victim.
Ah, robbery has all the same ingredients as larceny, but it adds an extra unique ingredient: force.
Exactly. Now we apply the Blockberger test. We ask, does each offense require proof of an element the other does not? We look at robbery. Does it require an ingredient that larceny does not? Yes, the use of force. Robbery has a unique element. Now we look at the other side. Does larceny require proof of an element that robbery does not?
Larceny's entire recipe is swallowed up inside robbery's recipe. There is no unique ingredient in larceny.
Correct. In legal terms, larceny is a lesser included offense of robbery. Because larceny does not have a unique element compared to robbery, they fail the Blockberger test. Therefore, they are considered the legally same offense.
What does that mean for our Sixth Amendment shield?
It means that if you are formally indicted for robbery, your Sixth Amendment right attaches to the robbery. And because larceny is legally the same offense under Blockberger, your Sixth Amendment shield automatically expands to cover the larceny charge as well. The police cannot secretly question you about the underlying larceny without your lawyer present.
But let's apply the test to Dave's situation. Burglary and arson. The recipe for burglary involves breaking and entering into a structure with the intent to commit a felony inside. The recipe for arson involves maliciously burning a structure.
Do they each have a unique ingredient? Yes. Burglary requires breaking and entering. Arson does not. Arson requires burning. Burglary does not. Because they each require proof of an element the other does not, they pass the Blockberger test. They are distinct, separate offenses. Therefore, Dave's Sixth Amendment shield for burglary provides zero protection against questioning for the arson.
That recipe analogy makes it incredibly clear. Now let's say the police are investigating me for the same exact offense I'm charged with. My shield is up, I'm out on bail. What is the legal standard for evaluating whether the police have crossed the line and violated my Sixth Amendment right?
The focus is entirely on purposeful state conduct. The standard was articulated in cases like Fellers v. United States and Messiah v. United States. The court asks whether the police or their agents took action designed to deliberately elicit an incriminating statement from the defendant regarding the charged offense outside the presence of their lawyer.
How does deliberately elicit compare to the Fifth Amendment standard for interrogations?
The Fifth Amendment standard under Miranda is a bit broader. It asks whether the police should have known that their words or actions were reasonably likely to elicit an incriminating response. It covers reckless or careless questioning, but the Sixth Amendment standard is sharper. Deliberately elicit implies intent. Did the state intentionally set out to bypass the attorney-client relationship and draw a confession out of the defendant? It requires a purposeful act by the government to undermine the shield.
Which leads us perfectly into our next major topic: remedies and sneaky informants. Because establishing all these complex rules and timelines is meaningless if there is no penalty when the state breaks them. What happens when the government intentionally undermines the shield and violates the Sixth Amendment? Does the whole case get thrown in the trash?
It depends entirely on when and how the violation occurred. The Supreme Court has created a tiered system of remedies. Let's start with the most extreme remedy: automatic reversal.
When does a court look at a violation and say, this is so bad, we have to completely throw out the conviction without even asking if it affected the jury's verdict?
The primary trigger for automatic reversal is the complete denial of counsel at the trial proceeding itself. This goes back to Gideon v. Wainwright. If a trial judge forces a defendant to face a prosecutor and a jury without a lawyer, the Supreme Court considers that a structural error. A trial without a defense lawyer is so fundamentally broken that the outcome cannot be trusted under any circumstances. You don't have to prove you would have won with a lawyer. The conviction is automatically overturned.
What about our wealthy defendant from earlier? The guy who had a brilliant, willing, private lawyer, but the judge erroneously disqualified the lawyer due to a misunderstood conflict of interest and forced the guy to use a public defender instead. Let's say the public defender did a phenomenal job, but the guy was convicted anyway.
Under United States v. Gonzalez-Lopez, that is also an automatic reversal. The right to the counsel of your choice is so fundamental to the Sixth Amendment that if a trial court wrongly denies it, it is considered a structural error that defies analysis by harmless error standards. The conviction is tossed, even if the replacement lawyer was objectively excellent.
Okay, those are the nuclear options.
Yeah.
But you mentioned harmless error standards. What are those, and when do they apply?
Harmless error analysis applies when the denial of counsel happens at a non-trial proceeding. Let's go back to our post-indictment live lineup from earlier. We know that's a critical stage, so you need a lawyer. Let's say the police hold the lineup without your lawyer there, and the victim identifies you. That is a clear Sixth Amendment violation. Does your entire trial conviction get automatically thrown out?
Under the harmless error doctrine, I'm guessing no.
Right. Under United States v. Wade, the appellate court will look at the entire record of the trial. They will ask, was this constitutional error harmless beyond a reasonable doubt?
How do they figure that out? What are they looking for?
They are looking at the weight of all the other evidence. If the prosecution's entire case rested only on that tainted lineup identification, then the error wasn't harmless, it caused the conviction, and the conviction will be reversed. But what if the prosecution also had crystal clear 4K security footage of you robbing the store, your fingerprints on the cash register, a full confession you made legally, and 3 other witnesses who knew you personally?
Then the fact that the lineup was flawed didn't really matter in the grand scheme of things.
Exactly. The appellate court will say, yes, the police violated the right at the lineup, and that identification shouldn't have been used, but the evidence of guilt was so overwhelming that the tainted lineup didn't actually change the jury's verdict. If the error was harmless beyond a reasonable doubt, the conviction stands despite the constitutional violation.
It's a very pragmatic, results-oriented approach. Now let's look at one specific non-trial proceeding. A preliminary hearing. Let's say I am brought before a judge for a preliminary hearing. I don't have a lawyer. I get confused, and I just blurt out, I plead guilty. Does that stand?
A case called White v. Maryland controls this. Pleading guilty is essentially conceding the entire case. If you do it at a preliminary hearing without counsel, the law provides a very specific remedy. You have the absolute right to withdraw that plea later. And crucially, once you withdraw it, the prosecution cannot use that brief moment of panic against you. They cannot introduce the withdrawn guilty plea at your actual trial as an evidentiary admission of guilt. It is completely wiped off the board.
Okay, let's dive into the scenario I set up at the very beginning of this episode. The jailhouse informant, I'm formally charged. Shield is up, I'm sitting in my cell. The guy next to me is secretly a police informant wearing a wire. Is it a violation for him to listen to me confess?
This is a classic exam scenario because it hinges on one tiny factual detail, the behavior of the informant. We have to compare 2 Supreme Court cases, United States v. Henry and Coleman v. Wilson. Let's look at Henry first.
In my opening scenario, the informant was asking me questions. What are you in for? How did you pull it off?
If the informant is actively asking you questions, initiating conversation about your crime, and trying to draw information out of you, that is a clear Sixth Amendment violation under United States v. Henry. The state cannot use an undercover proxy to deliberately elicit a confession that they are constitutionally forbidden from asking for themselves. The police intentionally created a situation likely to induce the defendant into making incriminating statements without their counsel. Because the informant's active questioning is attributed to the state, the confession will be suppressed.
They can't sneak through the back door when the front door is locked. But what about Coleman v. Wilson? How does that change the dynamic?
Let's change the facts. The police put the exact same informant in your cell. He's wearing the exact same wire, but the detectives give him strict orders. Do not ask him any questions. Do not bring up his case. Just lay on your bunk, pretend to sleep, and be a listening post. The informant follows instructions perfectly. He doesn't say a word. And you, sitting in your cell, unprompted, just start bragging to the room about how you committed the crime.
In that scenario, the state didn't deliberately elicit anything.
Exactly. Under Coleman v. Wilson, there is no Sixth Amendment violation if the informant acts merely as a passive listening post. The Sixth Amendment protects you from state interrogation. It does not protect you from your own unprompted talkativeness. You voluntarily volunteered the information to someone you thought was a friend. The fact that he was an informant is your bad luck, not a constitutional violation.
So the entire legal outcome hinges on whether the informant was active or passive. If I'm taking an exam, I need to look for verbs. Was the informant asking, prompting, or encouraging? Violation. Were they listening, overhearing, or sleeping? No violation.
That is the exact analysis required.
Okay, let's assume the police blatantly violate the rules. They send an informant in who aggressively interrogates me, violating Henry. Or they initiate questioning without my lawyer, violating the deliberately illicit standard. What happens to the confession? I know about the exclusionary rule.
Right. The general rule is the exclusionary rule, specifically the fruit of the poisonous tree doctrine, affirmed in contexts like Nix v. Williams. If the police violate your Sixth Amendment rights to get a statement, that statement is inadmissible in the prosecution's case in chief. Furthermore, any physical evidence they find as a direct result of that illegal statement, say you told them where the murder weapon was buried, is also generally excluded from trial.
But the outline indicates there is a massive loophole here involving impeachment. This sounds like another trap.
It is a critical trap established in a case called Michigan v. Harvey. Let's say the police improperly initiate a conversation with you without your lawyer, and you give a full, detailed confession to the crime. Because they violated the Sixth Amendment, the prosecutor cannot use that confession during their main presentation to the jury to prove you are guilty. It's suppressed.
Okay, the shield held.
But here's the loophole. Let's say the trial is going poorly for you, and you decide you want to testify in your own defense. You take the witness stand, place your hand on the Bible, swear to tell the truth, and then you lie to the jury. You say, I was never anywhere near the crime scene. I'm completely innocent.
The prosecutor knows I'm lying because they have my illegal confession in a file folder on their desk. Can they use it?
Yes, they can. Under Michigan v. Harvey, the prosecutor can suddenly pull out that illegally obtained confession and use it to impeach your credibility on cross-examination. They can ask, oh, you were never at the crime scene. Then why did you tell detectives 3 months ago that you were?
Wow. So the Sixth Amendment protects you from the government's initial aggression, but it does not act as a shield to protect you if you decide to commit perjury.
Exactly. The Supreme Court's philosophy is that the exclusionary rule is a shield to prevent police misconduct from tainting the state's case. It is not a sword that a defendant can use to lie under oath without consequence. If you take the stand and lie, all bets are off, and the prior inconsistent statements come in to prove you are a liar.
If we are summarizing remedies for the exam, denial of counsel at trial or denial of your chosen paid counsel equals automatic reversal. Denial at a lineup or other non-trial proceeding equals harmless error analysis. Active informants are illegal. Passive informants are legal. And illegally obtained confessions can't be used to prove you are guilty, but they absolutely can be used to prove you are lying if you take the stand.
A perfect summary of the remedies. Which brings us to our final, incredibly dense topic, ineffective assistance of counsel.
This is the elephant in the room. For this entire deep dive, we have been operating under the very generous assumption that the lawyer the state provides you, or the lawyer you hire, is actually helpful. We've talked about how to get them when they show up and how police try to bypass them. But what happens when the lawyer is just undeniably terrible at their job? Because the Constitution guarantees the assistance of counsel. Having a warm body in a suit sitting next to you doing crosswords is an assistance.
The Supreme Court recognized this in McMahon v. Richardson, stating that the right to counsel is the right to the effective assistance of counsel. But the standard for proving your lawyer was so bad that it actually violated the Constitution is shockingly high. The defining case that set the framework for this is Strickland v. Washington.
Tell me the story of Strickland, because we need to understand the facts to understand how high this bar really is.
David Washington pleaded guilty to 3 brutal capital murders in Florida. Against the advice of his lawyer, he confessed to the judge. During the sentencing phase, where the judge decides between life in prison or the death penalty, Washington's lawyer essentially gave up. He didn't seek out character witnesses. He didn't order a psychiatric evaluation. He barely put on a case for mitigation, basically just arguing that Washington had confessed so the judge should show mercy. Washington was sentenced to death. On appeal, new lawyers argued that his original counsel was unconstitutionally ineffective because he failed to investigate or present mitigating evidence that might have saved Washington's life.
Did the Supreme Court agree?
No. The Supreme Court upheld the death sentence and used the case to create a two-pronged test that defendants must pass to win an ineffective assistance claim. It is known universally as the Strickland test. If you are taking a bar exam, you must memorize these two prongs perfectly.
What is prong one?
Prong one requires the defendant to prove that their counsel's representation fell below an objective standard of reasonableness. The lawyer's performance must be shown to be deficient under prevailing professional norms.
Okay, objective standard of reasonableness.
Oh.
That sounds highly subjective in practice. What actually makes a lawyer objectively unreasonable? Let me throw some hypotheticals at you. What if my appointed lawyer is completely inexperienced? It's their first week on the job, they are sweating through their suit, they stumble over their opening statement, and they mispronounce the judge's name. Is that automatically ineffective?
No. The Supreme Court made it clear in United States v. Cronic that mere inexperience or the fact that a lawyer was assigned the case very recently is not enough to automatically prove deficiency. The system operates on a strong presumption of competence. You have to point to specific errors they made, not just their general vibe of nervousness.
Okay, what if they make a strategic decision that backfires catastrophically? Let's say my lawyer decides not to cross-examine the prosecution's star witness because the lawyer thinks the witness is so sympathetic that attacking them will make the jury hate us. But it turns out the jury just believes the witness completely because they weren't challenged. Bad strategy.
Bad strategy is almost never enough to satisfy prong one. Courts are incredibly hesitant to engage in Monday morning quarterbacking of trial tactics. What looks like a foolish mistake in hindsight might have been a calculated, reasonable risk at the time. Even failing to produce mitigating evidence at a sentencing phase, like in the Strickland case itself, or in a later case called Bell v. Cohn, has often been found insufficient to rise to the level of objective unreasonableness.
But what actually hits prong one? What does it take?
It takes colossal, undeniable failures of basic legal competence. Failing to investigate an obvious, rock-solid alibi witness. Falling asleep during a substantial portion of the trial. Completely misunderstanding clear, black-letter law and advising the client based on that misunderstanding. Those actions fall below objective reasonableness. But even if you prove your lawyer was objectively terrible, you only pass prong one. You still have to prove prong two.
What is the second hurdle?
Prong two is prejudice. You must prove that your counsel's deficient performance actually prejudiced your defense. Specifically, you must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different.
So let's say I prove my lawyer was asleep at the wheel, literally asleep. That passes prong one. But the prosecution introduced a 4K video of me committing the crime, my DNA was everywhere, and 50 eyewitnesses saw me do it.
Under Strickland, you lose on prong two. Even if you had the greatest lawyer in American history, they wouldn't have been able to overcome that mountain of evidence. The outcome of the trial would have been exactly the same. A guilty verdict. You have to prove that the lawyer's specific incompetence is the actual reason you lost. It is a massive, incredibly difficult hurdle to clear.
Are there any exceptions to this brutal two-prong test? Are there any scenarios where the courts say, okay, the lawyer messed up so badly here that we are just going to presume prejudice and you don't have to prove the outcome would have changed?
Yes, there are a few very specific structural exceptions. One involves the appeals process we discussed earlier. Under a case called Roe v. Flores-Ortega, if a lawyer's deficient performance causes a defendant to lose an appeal that defendant would have otherwise pursued, prejudice is automatically presumed.
Give me an example of that.
Let's say you lose your trial. You tell your lawyer, I want to appeal. Your lawyer says, okay, I will file the notice of appeal. But then the lawyer gets busy, forgets, and misses the 30-day deadline to file the paperwork. You lose your right to appeal entirely. You do not have to prove to the court that you would have actually won the appeal to get relief. You just have to show that the lawyer's incompetence cost you the proceeding itself. The court will presume prejudice and reinstate your right to appeal. And a later case, Garza v. Idaho, clarified that this presumption exists even if the defendant signed an appeal waiver as part of a plea deal. If they ask the lawyer to appeal and the lawyer ignores them, it's presumed prejudice.
Let's talk about another area where things can go structurally wrong. Conflicts of interest. We talked earlier about a judge disqualifying the lawyers because they represent two co-defendants. What if the judge doesn't notice the conflict and my lawyer represents both me and my partner at trial and our interests clash? Is that ineffective assistance?
It absolutely can be, and it's a procedural minefield. Federal Rule of Criminal Procedure 44C dictates that when co-defendants are represented by the same lawyer, the trial court must promptly inquire into the joint representation and advise the defendants of their right to separate lawyers.
What if the lawyer realizes there's a conflict and tells the judge, but the judge just ignores it and forces them to proceed?
Under Holloway v. Arkansas, if the attorney brings a potential conflict to the judge's attention and the judge fails to adequately investigate or appoint separate counsel, that failure requires automatic reversal of the conviction. Prejudice is presumed because the trial court failed its duty. But the rules change if nobody brings it up at trial.
What if the trial happens, nobody says a word about a conflict, but after I'm convicted, I realize my lawyer was favoring my co-defendant over me?
That falls under Mickens v. Taylor. If you raise the conflict issue for the first time on appeal, you have a much harder job. You don't get automatic reversal. You have to show that an actual conflict of interest existed that adversely affected your lawyer's performance. You have to point to the record and say, look, there is a plausible alternative defense strategy that would have helped me, but my lawyer didn't use it because it would have hurt my co-defendant. If you can prove that divided loyalty actually affected their choices, you win.
Okay, we need to hit one final massive area for ineffective assistance before we wrap up. Plea bargaining.
Yeah.
Television shows trials, but the reality is that 95% of criminal cases never go to trial. They end in plea deals.
Yeah.
Does the Sixth Amendment right to effective counsel apply when I'm just negotiating a deal in the hallway?
It absolutely does. The Supreme Court confirmed that the right extends to the plea bargaining stage in two massive 2012 cases, Missouri v. Frye and LaFleur v. Cooper.
What is the primary rule that came out of those cases?
The most testable rule is about communication. Defense lawyers have a constitutional duty to accurately communicate to their clients any formal offer from the prosecution to accept a plea on terms that are favorable.
So if the prosecutor pulls my lawyer aside and says, look, if your client pleads guilty today, I'll recommend 3 years in prison. If we go to trial, I'm asking for 10. My lawyer is legally obligated to relay that exact offer to me.
Yes. Let's say your lawyer thinks they can win at trial, so they arrogantly reject the 3-year offer without ever telling you it existed. The offer lapses. You go to trial, you lose. The judge sentences you to 10 years in prison. You later find out about the 3-year offer. You can absolutely claim ineffective assistance of counsel under Strickland.
But wait, how do I prove prong 2 prejudice in that scenario?
Yeah.
My subsequent trial was perfectly fair. The jury heard the evidence and convicted me. I obviously didn't have the evidence to win at trial. How was I prejudiced?
The prejudice isn't that you lost a fair trial. The prejudice is that you lost the opportunity for a much better outcome due to your lawyer's incompetence. To prove prejudice under Frye, you have to demonstrate a reasonable probability of 3 specific things. First, that you would have actually accepted the 3-year plea offer if your lawyer had told you about it. Second, that the prosecutor wouldn't have canceled the offer before it was entered. And third, that the trial judge would have accepted the terms of the plea deal. If you can prove those 3 things, you have proven prejudice, and the court must provide a remedy, often by forcing the prosecutor to reoffer the plea deal or adjusting the sentence to reflect the lost deal.
It's a fascinating look at how the Constitution protects defendants, not just from the state, but from the hubris or forgetfulness of their own advocates. If we are summarizing this massive final section for an exam taker, burn the 2 parts Strickland test into your memory. You need objective unreasonableness, A&D actual prejudice, a changed outcome. Remember that bad strategy or a rookie lawyer usually isn't enough to prove unreasonableness. And always remember that lawyers must pass along formal plea deals or they violate the Sixth Amendment.
That is the perfect distillation of a very complex doctrine.
Which brings us to the end of our journey through the Sixth Amendment. I want to sincerely thank you for being the ultimate guide today. We've taken a constitutional guarantee that is barely a sentence long and unpacked the sprawling, incredibly dense mechanical reality of how it actually works.
It's a fascinating area of law because it is constantly evolving as the court tries to balance the massive power of the state against the fundamental rights of the individual. Once you see how the gears connect the timeline, the offense-specific rules, the Blockberger test, the logic of the system really does reveal itself.
It really does. The Sixth Amendment is arguably the most powerful shield in the American justice system, but it is highly specific. It only activates when the state formally charges you. It only covers trial-like confrontations for that specific crime. And as we learned with Montejo and the informant cases, it can be bypassed or inadvertently lowered if a defendant isn't actively aware of where they are in the criminal justice timeline.
It requires vigilance. The Constitution provides the tool, but the defendant often has to know how to hold on to it.
Exactly. And before we go, I want to leave you with a final provocative thought to ponder, building right off that Strickland test we just discussed. We talked about how incredibly high the bar is to prove your lawyer was ineffective. We learned that a lawyer can fall asleep, make terrible strategic choices, or fail to present mitigating evidence. And the courts might still say, well, it wasn't objectively unreasonable or wouldn't have mattered anyway. Think about what that really means for our justice system as a whole. If the Constitution guarantees you the assistance of counsel, but the legal standard for that assistance is set so incredibly low, what is the actual baseline for justice in our courts? Is the Sixth Amendment guaranteeing you a good defense, or is it just guaranteeing that you won't stand entirely alone while the state prosecutes you? It's a question that challenges the very foundation of what we consider a fair trial, and it's something to mull over as you prepare for your exam, or just consider the reality of the legal system. So, the next time you think of a constitutional right as a simple, unbreakable shield, remember the Sixth Amendment. Remember the conditional programming, the hidden traps, and the invisible lines in the sand. Until next time, keep digging deep.